This is an appeal in the matter of Water Merricks, CBE, and MASTERCARD Incorporated and others.
Good morning, my lord. We, I think, are fairly familiar representation to the court, so I don't propose to introduce us all.
Have you agreed between yourselves on an order of play?
We have, subject to the court.
Yes.
We thought that we would start with applicable law,
Yes.
then 31(4), then exemptability, if that order is convenient.
I think that's fine.
And I understand we need to stop at lunchtime.
Well, my lord has another commitment this afternoon.
It's entirely my fault, I'm afraid.
So if we sit this morning, and then we'll sit the whole day tomorrow, and then as much of Friday as we need. I mean, I think both Lord Justice Green and I thought it was really a 2-day appeal with just a sort of a day in reserve. So I'd be reasonably hopeful we'd finish by lunchtime on Friday if we can. Let's see how we go.
We'll do our best. Yeah, of course, as always. The court will indicate.
No,
where...
if we don't shut up, we'll
Indeed.
end up going till 4 o'clock on Friday.
Or indeed that you will move
Saturday.
me along.
Okay.
Lord Justice
Good.
Green has obviously been here before in my submissions. I will open then on applicable law, and as the court will know, we have 4 grounds of appeal which are set out in the core bundle, tab 20, pages 323 to 324. I'll come on to identify those. Lord Justice Green may remember that permission was not granted for this appeal. It's to be determined on a rolled up basis.
Yeah.
And so I'm simply going to make my submissions and assume that you will decide both together.
Well, we have to decide both together. We're not going to do it in an artificial way.
As the judgment records at paragraph 73, there are 2 sets of relevant rules, as you'll have seen from our skeleton. The common law double actionability rules for the period from the start of the claim period on the 22nd of May 1992 until the 1st of May 96, and then the statutory choice of law rules in the PLIL MPA 1995, which I'll refer to as the 95 Act, and which apply for the period between the 1st of May 96 and the 21st of June 2008, which is the end of the infringement. And I will deal in my submissions first with the 95 Act, because that's the bulk of the period, before dealing briefly with the common law position. The tribunal held in its judgment, and the relevant paragraphs which I'll examine are paragraphs 88 to 90 and 92(1) of the judgment, that both sets of rules provided that the applicable law should be determined by reference to the location of the consumers who suffered loss when they made remote purchases. And because the tribunal said, looking at the claims it currently stands, loss, and I emphasise these words, is the issue that is most strongly in dispute in these follow-on collective proceedings. So the nub of the tribunal's reasoning was that because loss was effectively the most hotly contested issue in the proceedings as they now stand before you 24 years after the tort was committed, that is then determinative of the governing law. Now, we say, as you've seen from our skeleton, that the tribunal's approach is wrong. It is an approach that fails to give effect to the statutory test. It's also dangerous and could lead to unfortunate developments, including forum shopping by the parties. And I'll develop that. But I'm going to clear away 2 red herrings at the outset before I develop my submissions, because I anticipate these may be the 2 points that you will be particularly interested in. The first is that Mr. Merricks asked the court to treat the claim differently because it said that the court must have regard to the fact that these are collective proceedings brought under a statutory regime, the very purpose of which, it is said, is to provide compensation to consumers. That's paragraph 17 of my learned friend's skeleton argument. That point is completely irrelevant to the question of governing law. It is obvious that the identity of the claimants and the form of the proceedings cannot change the law applicable to the claims. And collective proceedings, as this court knows all too well, are simply a procedural mechanism for bringing multiple causes of action. And it was described, I think, by Lord Sales and Lord Leggett in the minority judgment in Merricks as a wrapper for pre-existing claims. So the wrapper doesn't change fundamentally the cause of action and accordingly can't change the law. And the tribunal, to be fair, did not regard that as a material consideration. The second red herring raised by Mr. Merricks on this appeal is that the significance of the tort elements are different because this is a follow-on claim. Now, that is, again, not correct. It cannot change the analysis of the underlying tort that we are at a different stage in the proceedings to an earlier stage where, for example, the acquirers were sued for the very same tort. The appropriate choice of law for a claim cannot change depending on the stage of proceedings. So, for example, if these were not follow-on proceedings and shortly before trial the defendant admitted liability, the appropriate choice of law would not suddenly switch. And that's essentially the argument that's advanced, but through the guise of it being follow-on and consumers. What it would also mean is that the applicable law would be unknown and unknowable till you saw the extent of the dispute after the commencement of proceedings. You could then switch and float as the proceedings develop, or you could tactically, before you plead, switch and float the law, and it risks transforming the determination of the applicable law of a tort from an evaluative assessment of the wrong into a strategic and tactical issue that a party can influence. Now, once those 2 points are cleared away, and I'll develop them, there is no case advanced against me. That is the case. That's the essence of the case. And so it's clear, and even on the tribunal's own judgment, it would be clear.
11.
Well, the
Position may
same,
be different with section 12.
the
Because
same
section
points
12
apply
too.
to section 12, but with an added burden, I
But
would suggest.
section
to you.
12 too, though, it does suggest, doesn't it, that you do look at issues like.
But you have to have displaced, first of all, you have to have displaced the general rule, which is a very high bar.
Yeah.
And secondly, it's still issues relating to the elements of the tort, not the stage of the proceedings. And that's what I would say to you is, if I had to tell you what the fundamental error in the tribunal's judgment was, it is that they applied a test which was not what is the significant element of the tort, which is what they should have done. They asked the question, what is the most significant element of the proceedings? And I'll show you that. So may I come on then to explain why the tribunal's approach and its decision was wrong as a matter of law? There are 3 reasons. The first is that the tribunal's approach is wrong as a matter of statutory construction of the 95 Act, both in regard to section 11 and section 12 independently. The tribunal started its analysis by suggesting that the statute, in particular section 11, was unclear. And they said that in their judgment. At paragraph 12, they refused permission on the basis that the statute was unclear as well. The express terms of section 11 and 12 of the Act are clear and have been clearly interpreted by the courts. They require the court to ascertain the governing law of a tort by identifying the country in which the most significant element of the events constituting the tort occurred under section 11(2)(c, or by examining any factors connecting the tort with another country if section 12 is invoked.
Yeah.
The approach they took, as I said, of applying a different test, namely what's the most significant element of the proceedings, was contrary to the statute, and this is my second point, contrary to binding authority. The relevant authorities are VTB and Deutsche Bahn. And they set out the correct approach to both 11(2)(c and 12. And they emphasise that significance is to be assessed by reference to the constituent elements of the tort. And VTB specifically says that it is impermissible to assess significance by reference to which aspects of the litigation will involve the most elaborate factual investigation at trial. Third, the tribunal's approach was wrong as a matter of principle, and I'll show you what I mean by that when we come on to the submission, but essentially it would mean that the governing law could change and be unknowable. So may I start with the 95 Act? And if we could go to section 11 of the Act first, which is in the authorities bundle at tab 4, page 8. So you'll see here that the rule, choice of applicable law, is described as the general rule. It applies, therefore, unless it is displaced by section 12. And we'll come on to section 12 in a moment. Section 11.1 is that the applicable law is the law of the country in which, and I emphasise the words, the events constituting the tort or delict in question occur. So you've got to tie it to the events constituting the tort. Where elements of those events occur in different countries, as they do in our facts, then the general rule is applied under 11.2. And since this is neither a case of personal injury nor property damage, we must look to 11.2c. The test under 11.2c is that the applicable law is the law of the country in which the most significant element or elements of those events occurred. So 3 points on the statutory language. First of all, the test is clearly prescribed by the statute. Secondly, the court is required to identify the country in which the significant elements of those events occurred. That limits the inquiry to those events, and the words "those events" refer back to the opening words of 11.2, where the elements of those events occur in different countries. And in order to understand what that means, we look back to 11.1, which says the events constituting the tort. So those events in 11.2c mean those events constituting the tort.
You can read in the elements of the events constituting the tort.
Indeed. And that determines the applicable law. And then my third point is
and you
that...
expect the events constituting the tort to be ascertained at the date when the tort's committed.
Exactly. Exactly. And the reason for that, just standing back, is what we're trying to do with this Act, and same with the common law, is that you are looking to identify the place where the tort was committed. And a tort is about, just standing back, what you are or are not permitted to do. It's broadly how you could define a tort. And 11.2 concerns where you've got a multi-place connection. And the question is, which country has the greatest claim to what you are or are not permitted to do? And you have to make the inquiry, therefore, at the time of the Act. Otherwise, it makes no sense at all. And that's precisely what the statute provides, as the Chancellor has just said. And the third point on the statutory wording is that it directs the scope of the inquiry to all of the events constituting the tort, not just a limited subset, but it also does not extend to events which go beyond those which constitute the tort, such as what happens in litigation or concession made years after it's been inflicted. Now, we would suggest nothing about that test is unclear, and the case law makes that very plain. So if we could look at VTB, please, which is in the authorities bundle at tab 25. And this is the Court of Appeal decision.
25.
25. And I suspect the facts are well known to the court, but if I could ask you to cast your eye over the head note, the key points to note are the head note in the held section at 4 and 5 about the issue about the alleged torts occurring, some elements in Russia and some in England. That's how this case came to be considered.
Yeah.
And the relevant part of the judgment starts at paragraph 145, which in my page numbers is 403.
Yeah.
And this, if one casts one's eye over, then going on to page 146, sets out the relevant rules and the decisions in which they have been examined are referred to in 147, including the Morin case that my learned friend relies upon, which I'll come to. And one then gets to the critical passage in 148. And if I could ask you, please, to read 148, and then I'll break it down. So there are 6 points that arise from the analysis in that paragraph, if I can break it down. First of all, as we've seen, that section 11 is the general rule and a geographical approach is to be adopted to that question. That's why I said the point of the section is to work out where the act was done. Secondly, section 11.2c requires an analysis of all the elements of the events constituting the tort of that matter. Again, this is all consistent with the statutory language, focusing the inquiry quite properly on the elements of the events constituting the tort. Third, in carrying out that exercise, it is the English law constituents of the tort that matter. And that's how, again, the inquiry is focused on the constituent elements of the tort. Fourth, at this stage of the analysis, the court is required to examine the intrinsic nature of the elements of the events constituting the tort. Now, that phrase is borrowed from Lord Justice Mance in Morin and Bonham's at paragraph 21, and I'll show you that authority in a moment. What Lord Justice Mance meant was that the court is required to examine the constituent elements by reason of which the alleged cause of action in tort arises on the law and on the facts. The court is required to do so without reference to other wider features of the overall litigation, such as the nature or closeness of any tie between any element and any country, or similarly, whether the cause of action is being argued in a particular way, with one element contested more than another. Rather, the exercise to look first at the component or constituent elements of the tort. So, for example, the tort of deceit requires proof of a false representation of fact, an intentional reckless state of mind, reliance, causation, and loss. Those are the components of that tort, rather than which bit the parties are going to fight over. And it's absolutely clear that that's what the Court of Appeal meant, because the Court of Appeal immediately in this passage goes on to say that what they do not mean at this stage is an examination of the nature or closeness of any tie between the element and the country where that element was involved or took place. So that's only potentially relevant if you get to section 12. Under section 11.2c, the court is required to examine the elements irrespective of where they occur geographically. The fifth point then is once those elements have been identified, the court is required to make a value judgment as to the significance of each of those elements. Now, the Court of Appeal explained what significance means for the purposes of 11.2c, contrary to the tribunal's judgment, which we'll come on to. It means, as they said, the significance of the element in relation to the tort in question. So just pausing there, in the context of the tort of deceit, looking at the four elements, one has to assess, in the case, which is the most significant element. But the critical passage for my purposes is the next sentence, or next half of the sentence, rather than trying to judge which involves the most elaborate factual investigation. And that's absolutely critical. First, because the significance of each element is to be assessed by reference to the tort and only the tort. And secondly, the significance is not to be assessed by trying to predict which element of the tort in question will be most central in the litigation which subsequently ensues. And therefore it's obvious that you cannot look at which is going to be most heavily contested, for example, or if there's going to be a concession or if there has been a concession. That forms no part of the inquiry. And to test that, an admission of, for example, loss would not render loss an insignificant element of the tort. It would simply shape the proceedings. And notably, what you also have to do to take the Chancellor's point is ensure that the applicable law of the tort has to be capable of identification from the moment it is inflicted. It can't be something that you look at subsequently or under a section 11 that changes. And if necessary, we can go to other provisions in the Act, section 9.4, for example, which talk about the fact that the applicable law applies to the issues. Except the inquiry under section 12 may be different, but under section 11, you're looking for one law, and it's got to be the law at the time the tort is inflicted. And that is why, fundamentally, the tribunal's approach doesn't work, because on the tribunal's approach, there would be multiple different potential laws, depending on how the parties position themselves in subsequent litigation, and that is impermissible. The sixth aspect on the test and the analysis is that the applicable law under section 11.2c is that of the country where the significance of one of the elements or several of the elements of the events outweighs the significance of any element found in any other country. So to go back to the way I colloquially put it, which country has the greatest claim to what you are or are not permitted to do at the time that you did it? And that's why we say in paragraph 16 of our skeleton, the approach to VTB in VTB to section 11.2c has two stages. First, to identify the elements of the events constituting the alleged tort, i.e. those elements without which the tort can't be constituted. And secondly, to reach a value judgment as to the significance of each element of the tort. Nothing has anything to do with how hotly contested each element will or will not be in the proceedings. And the tribunal's judgment and my learned friend's argument seems to conflate the issues. The approach that I've just outlined was endorsed by the Supreme Court, and one sees that from the speech of Lord Clark. I'll give you the reference. It is in the authorities bundle at tab 26, page 492, paragraphs 198 to 199, where he said that those propositions before the Supreme Court, the ones I have just outlined, were rightly accepted as correct. I can see the Chancellor's looking at that. So it's paragraph 199 in this court, and he looks at the principles that were cited in paragraph 147 and then on to 148 and says that they were correct. Now, at paragraph 13 of his skeleton argument, Mr. Merricks suggests that the tribunal's approach was not inconsistent with VTB because the application of the significance test was not addressed, as Mr. Merricks, in VTB. That is an impossible submission to follow. The Court of Appeal, as I've just shown you, in a judgment upheld by the Supreme Court, provided a step-by-step framework for carrying out the evaluative assessment required by Section 11(2)(c) of the Act, and specifically and expressly found, in the passage I have shown you, that the court is precluded from assessing significance by reference to those issues which involve the most elaborate investigation. So it's clear from the Court of Appeal's judgment endorsed by the Supreme Court that significance does not mean and cannot mean significance in terms of the part the events of a tort will come to play in the proceedings as they are framed before a court and the extent to which they are in dispute. So the question posed by the tribunal in its judgment, as I'll come on to show you, was considered and it was rejected in VTB Capital.
And you did get, I think, some support for your proposition from the way that the Court of Appeal actually went on to analyse the torts in the following paragraphs of this judgment. So that, for example, when they say that the judge got it wrong in the first instance, at paragraph 155, referring to what Lord Justice Mann said in Morin, and then giving their own view of the balance of the intrinsic nature of the tort. And it's only when they go on to look at section 12, in paragraph 159, they look at questions such as what is its, we have to ask, is it substantially more appropriately applicable of that other country to be the one that determines the issues in tort arising in the case? I mean, that's the first point in this part of the judgment where they refer to issues in the case.
That's right.
And it's in the context of section 12, not section 11(2)(c).
That's exactly right. And I was actually going to, if it's helpful, my lord, that you've raised that those paragraphs just to show the court while we're in this judgment 155 and 159, because I was going to come back to them and now I don't need to. That's absolutely right. And of course, I will come on to what was meant by arising in the case, issues arising in the case in the context of section 12. But the point is clear that it forms no part of the assessment under section 11. If we could then please go to the tribunal's judgment. And I have the judgment in the core bundle at tab 6. It's also in the authorities bundle at tab 41. I don't know which you are working from. The relevant reasoning is starts at paragraph 88. And if we could just, it's the 3 paragraphs, so if we could just go through them slowly. At paragraph 88, you see the wording of 11(2)(c) sets out a relative test, and the statute does not set out the criterion according to which significance is to be evaluated. Well, that's not quite right. It doesn't set out the criterion, but it makes it plain what you are doing and how it's to be done. It's by reference to the elements of the tort. Mr. Delaney correctly pointed out that significance is applied by reference to the events constituting the tort. Now, just pausing there, what the tribunal then goes on to say is, but that does not really assist. Now, it's difficult to understand that passage of the judgment because the whole section is geared towards one question, and it's not clear why the tribunal thinks that does not assist. It then poses a question with two potential answers, neither of which are correct. Is it significance in terms of the tort seen in the abstract, or significance in terms of the part that those events will play in the proceedings, i.e. the extent to which they're in dispute? Well, no one's saying it's seen in the abstract. You're looking at the intrinsic elements of the tort, but you are looking at what they are in the context of the case alleged. So if it's a tort of deceit, you're looking at exactly in the passage as my
In the abstract, it's an unusual expression. It's not the abstract. It's on the facts alleged, i.e.
Exactly.
in PTB, it was a conspiracy, or it was
Exactly.
a representation made from Russia to London.
Exactly as I was about to go to here, to the passage in paragraph 155 that my Lord Justice Snowden picked up. That's exactly the exercise you're undertaking. It's not in the abstract, it's on the facts of the case, but you're looking at the elements of the tort. You're not looking at the next question, what happens in the proceedings, because you simply won't know. And you don't, the governing law of a claim can't be shaped by what a party tactically does or doesn't do. So that's not the right way to put it. But then the second question that they ask, all the significance in terms of the part that those events will play in the proceedings, i.e. the extent to which they're in dispute. Well, we know that that's not the question because the Court of Appeal has already told us that's not the question. And in any case...
This is where you say that they really fell into error.
Completely fell into error.
Because this was a follow-on claim where the issue of restriction of competition had already been decided by the Commission. They thought that it wasn't actually an element of the tort.
Exactly.
You say, well, that's actually completely wrong because it's still an element of the tort.
Exactly. So there's two things that they fell into error. The first is exactly the point that you've just identified, my Lord.
Yeah.
But the second point is asking then the question in terms of the part those events will play in the proceedings really underpins the error because it shows what a disastrous approach that could be, and it's one that's completely prohibited to them as a matter of authority from the highest court.
I think you'd actually say, I mean, you're going to get onto this, but I suspect you'll probably say that's not even right for Section 12.
No, it's not right for Section 12 either.
Because it was no part of the Court of Appeal's analysis in VTB to sort of predict how things might play out in the proceedings.
Exactly.
The question there was the sort of factors that talked about in terms of Section 12 were just things outside the intrinsic elements of the tort, but were pre-existing relationships that the parties might have.
Precisely.
And
at the time.
And as I remember, I mean, I think the closest an argument was, I think there was a big debate about where the witnesses might be and that sort of thing, but even then I think you'd probably say that's not right either. And it doesn't play a great part in the reasoning, I don't think.
No. And when we come on to 12, the reason why we don't even get into the territory at all is because you actually have to displace the general rule, and it's quite clear from Lord Clark's judgment that displacing 11.2c is going to be almost impossible. Very rare case.
It's a high threshold.
Exactly. And the point is that...
Because if it's an 11.2c case, you've effectively gone through the exercise.
Exactly. So you can't then suddenly find that something...
that puzzled me until I read what Lord Clark said, because when I looked at 11.2c and 12 together, I thought, hang on a moment, how could you get to a different system of law via 12 than you would do via 11.2c?
Well, and that's why the words he uses are very rare case, and commentary says exceptional.
It's a sort of fail-safe.
Fail-safe.
If 11.2c actually leaves you with a result which is
exactly
logical, unworkable, etc.
Exactly. So this is where you see that it's gone disastrously wrong, and it's then said the question was not addressed in Deutsche Bahn, where claims were standalone claims where infringement was in issue. Now again, those words "in issue" show the mistake, because it's not what's in issue, it's what's the element of the tort. And then they accept, and this is why in a sense this is, as I said, this is actually quite a short point on section 11(2)(c), because the tribunal themselves recognise that if they're wrong on the question they posed, the latter question, which they are, then they would have followed Deutsche Bahn, i.e. finding that infringement was the most significant element, the restriction of competition. So the tribunals actually answered the point, so once one sees where they fell into error, then the answer is clear. And then the next point is that they then go on to justify what they did by the Protea leasing case. And it's said that that gives a flexibility, and I'm going to show you that case, but I can tell you now that Lord Justice Moore-Bick was not saying, ignore the statutory language, you can do what you like, and do exactly what the Court of Appeal said in VTB was not to be done, and we'll see that. So one's seen how they fell into error, and then one goes on to see even more in paragraph 89. Ms. Dimitriou's suggestion that significance should relate to the role that the event will play in the case before the court has attraction. Although we recognise the force of Mr. Lane's objection that if a disputed issue were subsequently conceded, then that could potentially lead to a change in the governing law. So what they're saying is that you'd have one law up until the point someone makes a tactical or other concession, and the governing law switches just before trial. That just can't be right and would be utterly dangerous, and you can see all the problems.
Well, there are authorities, aren't there, about the floating popular law?
Exactly.
I mean,
Exactly.
they're common law authorities, but basically
You can't
they
have
said
it.
it's a no-no.
That's right. And I think 9(4) of the Act also would have that in mind, because it talks about the applicable law to the issues in the case, not to several different issues.
Yeah.
So this is a prohibited approach. And you see then the reason they've reached this conclusion, in reality, there is no prospect of the loss being conceded in the present proceedings, since that is what the case is all about. Well, surely that's what every case is all about. So that just doesn't work.
Well, I mean, I think your point is you can't reverse engineer the approach to the legal test by prediction as to what might or might not be the case in a particular
Exactly.
issue.
Exactly. It's disastrous.
Yeah, you can't say, well, it doesn't matter if we've got the approach wrong because it won't matter in this particular case.
That's right. But their analysis is also wrong here, because as the Chancellor said, that it's been put on the basis that the nature of the follow-on claim. But just to take that point head on, it's not an element of the tort that loss has been passed on. The relevant element of the tort is that loss has been caused by a breach of competition law.
Yeah.
The fact that the claimant can only prove that element in one particular way doesn't elevate the element to being the most significant for the purposes of section 11. We then see that the tribunal does not then have regard to the fact that it is a consumer claim, and of course it can't be relevant that it's a consumer claim to the governing law. Not least because you may remember that the Rome 2 did actually provide a regime for consumers, whereas the 95 Act deliberately didn't. So there's no reason to treat consumers differently. And then paragraph 90, in the end, although not without hesitation, we consider that the assessment of significance should be made on the basis of the significance that the various events will have in the actual proceedings before the tribunal. Now that sentence says it all, because how can you possibly know? And how can they know? What happens if something changes in any case the very next day? And that's why it is a completely erroneous approach, and the Court of Appeal, this court, needs to reset the position, because that would be an extremely dangerous precedent to leave extant.
On that basis, you couldn't determine the proper law of the tort until at some stage later in the proceedings,
That's right.
after you had to determine issues like whether or not permission to serve out of the jurisdiction should be given.
That's right. So even my learned friend is driven to saying,
It has to be determination at the outset, otherwise it makes no sense.
that's right. Even my learned friend is driven to saying you could do it on the pleadings. We say, well, actually, on the tribunal's wording, the significance they will have in the actual proceedings wouldn't necessarily even be known at the pleading stage. So when is it going to be known? And the worst point, as we say in our skeleton, is any concession or adjustment to the proceedings would change the governing law on this analysis. So it simply can't work. It's too uncertain. It doesn't actually fulfil the statutory purpose. And it also would lead to forum shopping in a way that this court could not ever endorse. And my Lord, I've made most of my points therefore on section 11, but just to pick up the references in my skeleton, we identified 6 key reasons as to why the tribunal's judgment was wrong in paragraphs 23 to 33 of our skeleton. And just to run through them, first of all, the tribunal's approach is contrary to the language of section 11(2)(c) of the Act and statutory purpose. I've addressed you on that. Secondly, the tribunal's approach is inconsistent with Court of Appeal and Supreme Court authority. I've shown you that. Thirdly, the tribunal's approach is contrary to previous relevant authority, which is the Deutsche Bahn case, and I'll briefly show you that if I ascertain from the comments I've had you're familiar with it. Fourthly, that there's no authority in support of the tribunal's approach, and although they relied on Pratea, it doesn't support the analysis, and again I'll show you that. Fifthly, the tribunal's approach is incoherent and wrong in principle, and that's the point we have been discussing about the floating law and the uncertainty. And sixthly, in this case, multiple significant elements of the tort occurred in the place where the restriction of competition occurred. So the tribunal's approach was actually wrong anyway, because they couldn't have said that loss was the most relevant point anyway. So may I briefly show you the Deutsche Bahn case, so I've shown it to you. And this is addressed at paragraph 25 of our skeleton, and it's in the authorities bundle at tab 31.
31.
31. So the facts are set out in paragraphs 1 to 3. The defendants are the MasterCard group of companies, and it was a trial of a preliminary issue, namely the applicable law in respect of claims relating to 4 sample countries known as the test country claims. The relevant part of the judgment starts at paragraph 38. And you see there that Ms. Justice Barling goes through the relevant sections, and paragraph 148, which I showed you of the Court of Appeal decision in VTB.
Paragraph 37.
It's paragraph 38 on page 992 of the bundle, page 1776 of the report. So he quite sensibly starts with, under the heading, the correct approach to section 11, paragraph 148, which I've shown you. He cites then at paragraph 39 a passage of from Dicey and Morris, which is worth just reading. and the phrase identify the ingredients of the alleged liability is a useful phrase. And then at paragraph 40, he characterises the approach to be taken as threefold. And I'll let you read that. And what you see is he's focusing on the tort in question. And at paragraph 41, he refers to the court considering the significance of the relevant elements of the tort in light of the facts. Now, that is the point that my learned friend has seized on in her skeleton argument at paragraph 16 as support for the approach the tribunal took. But as my Lord Justice Snowden rightly identified, paragraph 155 of the VTB Court of Appeal decision makes it absolutely plain what type of exercise the Court of Appeal had in mind, and Mr. Justice Barling had in mind, which is to look at the facts of the tort, not what the tribunal did. We then get to the critical reasoning in paragraph 42. And this is precisely what the tribunal should have done, which is to focus on the tort. And of course, the present proceedings are founded on the very same tort. MasterCard is said to have infringed Article 101.
And say that defines the elements of the tort.
It does.
That we're concerned with.
It does.
In this case.
It does.
And the fact that the restriction of competition is determined by the Commission doesn't prevent that from being an element of the tort.
No, it's the foundation of the tort. Without it, you couldn't have the tort.
Without it, there wouldn't be a tort.
Exactly. And what's the critical point for this court's purposes, the tribunal have almost recognised that, which is why they went down the route of trying to say, but this is different because it's a follow-on action, which of course is not anything to do with the tort. It's the stage in the proceedings as to where we've reached and how you prove the loss. So it's absolutely clear that from their own judgment, as I showed you at paragraph 88, that had they not tried to have that particular distinction, they accepted that they would have followed, and they say that in terms, the Deutsche Bahn case.
You've got four elements there, so duty, breach, causation and loss.
That's right.
So what the Commission did was not concerned with the latter two, they're not concerned with causation and
That's
loss.
right.
And so it then comes down to, you have to identify at a broad level what those various components, what those headings comprise, and then attach them to a country.
That's right.
And causation, so the Commission decision, I mean, there's a lot of analysis of whether one's focusing upon where the merchant acquiring bank is or something like that, but one's got to also look at causation and loss.
That's right.
As relevant connecting
That's right.
factors.
That is absolutely right. But what Mr. Justice Barling found is, having done that exercise, he regarded the infringement as the foundation of the tort and therefore the most substantial element, rather than the...
Why is that necessarily the case? Because you obviously, that's right, it's a sine qua non, but you can fail on causation, you can fail on loss. Why is the breach more or less important than anything else?
Because in this case, what he found was that the infringement was the nub of the tort, and without it there wouldn't have been the tort. Now I understand that you might say that's true of causation as well, but he looked at all the, I'll come on to show you his reasoning. He looked at why he considered that to be the fundamental element, and before I show you why, what I would just ask you to bear in mind is the tribunal said they would have followed this, but for where we are in the proceedings, if you like. So in a sense, once you're with me on, but the fact
Even
that,
if one sets that aside, the way you are,
yes,
just looking at it in the abstract.
then the tribunal accepted that this was the right reasoning, and can I show it to you? So he moved on to the next stage in the analysis at paragraph 52.
If you're looking at the position as at the date when the tort's committed, of course, as at the date when the tort's committed, that's prior to any decision by the
Exactly.
Commission. So you
Exactly.
can't, as it were, airbrush out the
That's right. You
the
can't.
restriction of competition.
That's quite right, and that's why I said this tort was committed 24 years ago, and, as alleged. So you can't assume that you analyse it 24 years down the line. You have to look at it prior to the decision on infringement, unless you're going to be saying that the law is set by where you are in the proceedings, which is the wrong approach.
Where are you going after?
So I was going to go, in fact, if I may go to paragraph 50, please, first.
Yeah.
Now, can I just ask you about that? I'm not certain there's much difference between a collective and an individual claim. If you've got one claim 25 years ago, you've got and it's a purchase from a merchant, let's say in France.
Yes.
You've got claimants based in this country, you may have some defendants based in this country, you've got merchants in France, you may have the banks between France and the UK. So you then multiply that by X million, but you get the same profile. Does it make any difference whether it's collective or individual? In terms of the structure?
It makes
of
no difference. The collective is a wrapper.
Yeah.
Makes no difference.
But the analysis
Analysis is the same.
I can see the force of you saying doesn't necessarily strengthen the case that there's a collective action, but looking at the profile of any tort, you've still got a substantial element in the UK, namely the claimant, where the loss was manifest. You've still got to do the balancing exercise between the various components.
Yes, you do.
Because the tort is committed
Yes.
against the individual claimant.
That's right. You still have to do the balancing exercise.
It isn't a tort that's committed against a class.
No, you have to do the balancing exercise. But you want the point is that how you may end up with different applicable laws for different claimants depending on how you set the test.
Yeah.
But the point is you analyse the tort.
That would go to the appropriateness of the collective proceedings
That's
if it
right.
went anywhere.
That's right. Then that's not you can't, because as I think it was Lord Justice Leggett said in Merricks in the minority judgment, it's a wrapper. It doesn't change the fundamental causes of action underlying it. Now, what I can show you is, so if we go to paragraph 52, what Mr. Justice Barling did was then to identify the country in which each of the elements described A, B, and C, and he said neither side had suggested the element of a potential effect on intra-EU trade needs to be addressed. So what he did was go through the analysis in that way of each element, in the way that my Lord Justice Green is positing to me, which is correct. And skimming through the judgment, what we see is, on the facts, the restriction of competition was in the product and geographic markets in which the claimants operated their retail business, paragraph 55. The location of the loss was the country in which the merchant was based at the time of the transaction upon which a charge was paid, paragraph 56, and the location of the setting of the EEA MIFs was in Belgium between 1992 and 2006, and from 2006 was in the US, paragraph 88. So he looked at each element. And then from paragraph 109, he considered the relative significance of each of those elements of the tort. So we can move to paragraph 109, please.
Just before we move on, the location of the loss in paragraph 56, that's for the merchant. The present claim is mainly for individuals, isn't it? It's for the consumer, not the merchant.
That's right. And it's the follow-on proceedings.
Yeah.
Exactly.
Yeah.
If we could then look at 109, he starts that exercise. And the claimants in the case before him contended that the most significant event was the setting of the MIFs.
Yeah.
And so Belgium, until 2006, was the relevant and most significant element, and that's paragraph 1, 110, and significant country. But at paragraph 121, Mr. Justice Barling found that the most significant element of the events constituting the tort was the restriction of competition. And if we can just go through that paragraph.
He also rejected that it was the loss suffered by the claimants, even though that was a significant element.
Exactly.
So,
Exactly. And the reason why he said, and the highlight of his reasoning, which is excellent in paragraph 121, was that competition doesn't occur in the abstract, but upon a market. And a restriction of competition is a necessary element of the infringement of 101, unlike loss. If there's no restriction of competition, there is no tort. The mischief at which Article 101 is aimed at is the protection of the competitive process, and competition doesn't occur in the abstract on a market. And the subject of the restriction of competition was the separate national markets for providing acquiring services. These were the theatres of the wrong allegedly done by the defendants. So that's the essence of the reasoning. And here, in this case, at paragraph 124, he found that the fact this was also the place of the claimant's loss reinforced his conclusion, but it was not the determinative factor. Now, what we say here is that each of the reasons applies equally to this case. If there's no restriction of competition in a case based on a breach of Article 101, then there is no tort. And an admission, as the Chancellor has said, wouldn't alter the analysis of what constitutes the tort. The restriction of competition occurred in the national acquiring markets, which were the theatres of the wrong. And as the tribunal confirmed at paragraph 90, as I've shown you, it would have reached the same conclusion as Mr. Justice Barling if it had adopted what we say is the right approach, the same approach to section 11.2c. It was only because it was influenced by the follow-on fact that they were at a follow-on stage and loss was going to be therefore the main element in dispute that it went down a different route. Can I look then at the Protea case, because that's the high point of the tribunal's reasoning and my learned friend's submission. Right. Because it said at paragraph 18 of his skeleton that he can draw support from that decision. It's a first instance decision of Mr. Morbick, as he then was, Mr. Justice Morbick, and it's in the authorities bundle at tab 19.
tab
19, page 221. It's the passage I'm going to look at, paragraph 78. So if we go to paragraph 78 of page 221, please, this is the relevant paragraph that is relied upon. And what you see here in the passage that's quoted in the tribunal's judgment and relied on by a learned friend is the last sentence, which is a much more flexible principle that Mr. Justice Morbick, as he then was comparing the position under the common law and the 95 Act. And that's where he says, 6 lines up from the bottom, the 1995 Act establishes a new set of principles. And what he's saying is you no longer have to look at, under the 95 Act, where in substance the tort was, quotes, committed. You can now look to the country in which the most significant element of the events constituted the tort occurred, which gives a degree of flexibility. And he says at the end, it might yield different answers in different cases. Now that's saying no more than the Court of Appeal in VTB was saying in paragraph 155, and no more than Mr. Justice Barling found in Deutsche Bahn. There might be different answers in different cases.
What you're saying might apply here.
Well, it might, with the analysis of loss, yes, it might. But the problem is that you have to not be influenced by, and I'll come on to this, the point of principle, where we are in the proceedings and the fact that there are consumers. So you have to still start the action at the outset, and I'll show you, because otherwise, and this is my point on principle, you would be applying, my lord, a different law to the earlier stage of the action against the acquirers to the consumers, and that's prohibited because the applicable law would change just on how the loss was being passed down the chain.
And your submission of much more flexible is simply a reference to the test which went before.
Exactly.
It's a comparison between two tests.
Exactly.
The later test is the more flexible of the two.
That's right. And you can see that on the face of it doesn't suggest. And the quote from Mr. Merrick's skeleton is, he says that Protea leasing suggests the 11.2c exercise must be applied, quote, in light of the circumstances of the proceedings. Well, that's not what this paragraph says. The circumstances of the proceedings are not what Mr. Justice Moore-Bick has in mind. And you can also see this from the other case my learned friend relies upon at paragraph 19 of her skeleton, which is the Morin case I mentioned, Lord Justice Mance, and that's in the authorities bundle in the next tab at tab 20. As I said, this is, I think, where the language of VTB came from, the intrinsic elements. Lord Justice Mance refers to Protea leasing. Just going to find the right. It's the relevant paragraph is paragraph 18 and then 19. That's page 269. So there was a reference to Protea leasing where Mr. Justice Moore-Bick suggested caution about turning too readily to the earlier authorities when the 1995 Act establishes a new set of principles. I think that caution well-founded. And all that's being said here is we don't want to have submissions complicated by increasing the outdated debate about the precise nuances of old law. And he talks about the arguments becoming clogged with an overlay of arguments about the past. The legal elements of the tort of misstatement are clear enough, and the new statutory wording of the Act requires a value judgment about their significance in the context of the particular facts in issue. So you see that's precisely how then we see the judgment in VTB was formulated. In the present case, elements constituting the alleged tort occurred both in England and Monaco. But I agree with the judge that the significant elements occurred in Monaco. And he then goes through the exercise. So he refers in paragraph 19 to the making of a misstatement in a catalogue, the continuum of activity constituting reliance on the facts of the case and where the loss was suffered. So it's clear that that's what he meant when he talked about the particular facts in issue. And he didn't mean any suggestion about how it would come to play out in the proceedings before him. And you see that even further then at paragraph 21. But significance under section 11 directs attention to the extrinsic nature of the elements of the tort. So that's where the phrase comes from.
Actually, just to be clear on the transcript, intrinsic, not extrinsic.
Intrinsic,
It
sorry,
actually makes a difference which one you use. It's intrinsic.
Intrinsic.
Yeah. You don't look at external factors
Exactly.
at this stage.
Exactly, thank you, my lord. And Lord Clarke expressly agreed with Lord Justice Mance in VTB Capital at paragraph 200 of the Supreme Court judgment. The reference to that is Authorities Bundle, tab 26, page 492. The fourth argument in the skeleton is that there's no authority in support of the tribunal's approach, and that follows from what I've just shown you. Those authorities don't support the tribunal's approach, which takes me to my fifth point, which is principle. And I've developed this already. The three key points are: on the tribunal's approach, the court would not determine the applicable law of a tort, either in light of the elements of the cause of action or the facts that have constituted it in any particular case. Rather, it would be some retrospective approach, waiting to see how the tort was litigated and when it became apparent what each element's role was in the proceedings. And there may be no identifiable law at any time. In that case, it may be apparent on the pleadings, it might not be determinative until the CMC, it might not be certain in some cases until after the conclusion of the trial, and it might change if there was a concession or an admission. And you can illustrate this by the facts of this case, and I'm just answering, I think, Lord Justice Green, some of his questions. The period of time in respect of which the 95 Act is relevant to this claim is the 1st of May 96 to the 21st of June 2008. The EC decision was not reached until the 19th of December 2007. The proceedings were not issued until September 2016. And so in relation to a tort inflicted on the 1st of May 96 on the tribunal's approach, the applicable law could not have been identified more than 20 years later. Secondly, the tribunal's approach creates what we called at paragraph 27 of our skeleton as a floating proper law, because it would only crystallise on the tribunal's approach when it was clear how the case would be argued. And the tribunal purported to deal with my point on floating law at paragraph 89 of the judgment, when it said there was no prospect of loss being conceded, as I showed you. But it fails to be engaged with the principled objection. And it could put the determination of the applicable law entirely in the hands of the defendant, who could make tactical concessions. And so it's another reason, if one is talking about actually consumer protection, you wouldn't want to go down that route. The third point is that the tribunal's approach means that the governing law for MasterCard's conduct would shift depending on the identity of the claimant and the point in the stream of commerce at which the claim is made against it. And again, I think this answers a point that I alluded to in answer to Lord Justice Green. Mr. Merrick's case is that the alleged overcharge was paid by merchants to their acquiring banks first, before passing on to the consumers. So if this was a claim brought by the merchants, the applicable law of the tort would be the law of the location of the restriction of competition, as it was found to be in Deutsche Bahn. The loss caused to the merchants is through the passing on of the alleged overcharge by the acquiring bank to the merchant. The consumer's loss is then caused by an alleged passing on of the overcharge from the merchants to them. So you've got to have the same applicable law in respect of all the streams, because it's one claim, just different streams of commerce. And you can't have the law shifting depending upon the identity of the claimant. Put another way, it's not an element, as I said, of the tort that loss has been passed on. It's just how it's being proven. And if I give you an example, suppose that in a merchant claim, the direct contracting party with MasterCard is subsidiary 1 of the merchant, and it recharges the fee to subsidiary 2. The fact that subsidiary 2 of the merchant establishes its loss by the recharge does not mean that the loss element of the cause of action is suddenly far more important than the restriction of competition element. And that's precisely what's being said here.
So if you had a partial pass on, you would have a claim by the French merchant in France and the English consumer in England, because they would both have suffered loss from the same transaction. And you see, what would be the applicable law there? Would you have two claims? You'd say it's still one applicable law
It's one
law.
applicable law.
I'm not so sure about these last set of submissions, I have to say. Are you saying that the elements, what are the elements of the tort so far as the consumer is concerned in this case?
The same elements. You still have to show that there was an infringement. The reason why the tribunal fell into error was just simply because the infringement was admitted rather than in dispute.
Yeah, no, I understand that point.
Yeah.
No, I'm just thinking about the element of loss, causation and loss. These are claims by the consumers in this case.
That's right. So
And saying we have suffered loss.
but you're just saying that the law should be different if it's a direct claim
Yeah,
rather than an indirect claim.
As I heard you, and I think as I read on the transcript, is this right? You're saying there cannot, as a matter of concept, be a different applicable law to a claim by a merchant and a consumer.
But
In the same chain, in the same case, yes.
if it were just postulate, and I know nobody's arguing this, but just to test the point, postulate that causation is the most significant element. In your examples, the causation of the loss for the merchant is in France. The causation of the loss for the consumer, the customer, is in England. So in that
Well,
sense,
it may be.
it's not the same tort throughout, is it? I mean, it may not make any difference if you're
Well, it's the
right
same
in your
tort.
primary point
Yeah.
that for either tort, either the tort committed against the merchant or the tort committed against the consumer, the most significant element is the restriction on competition. I follow that point. It's not on analysis exactly the same tort.
Well, I would say it's the same tort, but the example you're positing to me is that the different elements may be more significant within the tort on the value judgment. But what I'm saying to you is that you have one claim here, and it's a cause of action where people are coming in at different stages, if I can put it in that way. So the recharge element, so you have the example I gave you, someone suffers a loss and then recharges it to someone else. What you can't have is the applicable law changing depending on the stage of the action and the identity of the claimant.
Yeah, what I'm struggling with, I think, is the submission is the same tort, because it isn't the same tort, I don't think, because the victim of the tort is different in each case.
But it's still based on
relevant
Article 101.
element must be who is the victim of the tort.
Well, that's not a part of the legal test. The legal test is breach, causation and loss.
Well, I mean, this is illustrating a point you slipped in quite early into the submissions about what really we're talking about with tort, and you're saying it's somebody doing something they shouldn't have done.
That's right.
And
It's
if
not
you-
who they do it to.
If you characterise tort in the way you just described it, you're going to get the answer you wish.
But that is what a tort is. It's not, let me put it another way. We don't in this jurisdiction say it's a tort if you hit me but not if you, that's not a good example. It's a tort if you deceive me but not them. So the identity of the victim doesn't define the commission of a tort in this jurisdiction.
It all depends on what your tethering peg is. So you've got duty, breach, causation and loss. Your duty is not to harm competition in the EEA, which covers the United Kingdom. Your breach here covered the EEA as well as other national territories. Your tethering peg there comes from the definition of the relevant market as the merchant acquirer's bank, effectively. That's your tethering peg, which would take you, say, to France as opposed to England. And then you've got causation, which on this hypothesis is England, and loss, which on this hypothesis is England. So it ultimately comes back to, in the merchant case that Mr. Justice Barling was looking at, whether the most significant fact is the merchant acquirer's banking facility, which is not in the UK. And the question is, in this case, whether that is still the most significant tethering peg.
Well, I'm going to come on to that, but just to go back to the prior question, you may be exercising a different value judgment over the significance of elements of the tort, but the elements of the tort remain the same, and the identity of the victim isn't part of that analysis. That's the first point.
You may be right for this type of tort.
Yes.
I'm not sure you're universally right. I mean, I'm trying to think desperately of a tort where the effect on the victim or the effect of what is done by the alleged tortfeasor is actually more significant, whether it's something like inducing a breach of contract or something like that.
I think the only one...
But I'm trying on my, as it were, sitting here, which is always quite difficult while trying to listen as well. But I think what you're saying is on this particular type of tort, it would be odd to reach a different conclusion on the applicable law depending on whether it was the merchant or the consumer.
That's right.
I'm not sure you necessarily need to go further.
I don't need to go further, and I also would say that it's something that the 95 Act could have done but didn't provide, given the provisions of the comparable provisions of Rome 2. So I can make that point as well. But I don't need to go broader, but I would say to you that you're looking at the constituent elements of the tort. If there is a tort that has a constituent element as to the identity of the victim, it's not this one. So I don't have to go beyond my submission. But my point is all you have to do is look at the elements of the tort, not what is in play in the actual proceedings. Then can I come on to the significant elements of the tort in this case? Because I think that's what you're pressing me on. The only point I was going to make, which may not be a good point, because I appreciate you can take a different approach, but is just to remind you that the tribunal's approach was, if they applied the Deutsche Bahn approach rather than looking at the actual proceedings, they would have agreed with Mr. Justice Bartley. We address the point that I think my Lord Justice Green is particularly interested in paragraphs 30 to 33 of our skeleton.
Yeah.
Essentially, there are 4 points as we make in paragraph 30. First of all, the home country of the merchant is the place where competition was affected, because this is the location of the merchant's acquiring bank. And the tribunal recognised at paragraph 71 that the parties to this case were proceeding on the assumption that a foreign merchant would be based in the same country as its acquiring bank. And that's the reference for that is in the judgment at paragraph 71. The EC decision found at Article 1 that EEA MIFs restricted competition contrary to Article 101 because they set a minimum price that merchants had to pay to the acquiring bank for accepting payment cards in the EEA. And the reference for that, we don't need to go to it, is Authorities Bundle, tab 45, page 1820, capital A. So the place where competition was restricted, according to the decision, was at the interface between merchants and their acquiring banks. Now, in accordance with this, in Deutsche Bahn applying VTB, the place where competition was affected was the merchant's home country, and that was said to be the most significant element of the tort. And we say that must apply here, and read this case likewise, as it's founded on exactly the same point. And it's the result the tribunal said they would have reached at paragraph 88, save for its different approach. The second point is that the acquiring banks that actually paid the EEA MIFs to the issuing banks were located in that same foreign country. Thirdly, the alleged higher merchant service charges were paid by merchants in that country. And Mr. Merrick's case is that the alleged overcharge, as I've said, was paid by the merchant to their acquiring bank before it was passed on to the consumers. So if this was a claim brought by the merchants, and the applicable law would be the law of the location of the restriction of competition, as found in Deutsche Bahn, so all you're left with, those are all the elements, and that's why the only point you're left with is that the consumer's loss is the passing on of the overcharge from the merchants to them. And it's logical that the applicable law should be the same in respects of claims made for the same loss Because it's the passing on is how you prove it. It's not an element of the loss. And you have to have, that's why I say it's the passing on of the loss is not the same as a different form of loss. And fourthly, merchants sold to consumers from a base in the merchant's home country. Now, so you've got, in fact, on the facts of this action, you've got all those points in favour of where the applicable law should be. And against all those factors is the single point that consumers suffered loss in the places where they resided. But it's...
Sorry, can I just try to follow this through?
Yeah.
On the facts of this case, the class includes consumers in this country who will have bought goods remotely.
That's right.
From a whole variety of jurisdictions.
That's right.
And the merchants' banks, therefore, the merchants and their banks are in a whole variety of jurisdictions.
Correct. And this comes into play in section 12.
I was going to say,
Yeah.
we're going to get onto this in section 12.
Yeah, and that's one of the reasons, as you know, the tribunal gave.
So if you focus, as Mr. Justice Barling did in, I think it's paragraph 50 of Deutsche Bahn, on this question of, is the restriction of competition an element of the tort, which I think is where he reaches the conclusion it is, contrary to the contrary argument in that case.
That's right.
The restriction on competition in our current case will be in a whole variety of different markets in different countries.
Maybe, yes.
Well,
Depending, well, it will be in a variety. I was pausing on the
number of.
scale of it, yeah.
okay, a number
Yeah,
of.
a number of.
So, I mean, because the purchases are remote from merchants in a number of
That's right.
countries.
But that forms no part of the assessment under section 11. Because you're not, if you remember, it's said in terms, you're not tying the elements to the geographical location at the point at which you
No,
are
but you
identifying the
are.
elements.
But for each consumer, you are looking at the facts of the case. And so for each consumer, their claim, in the individual claim that they have within the wrapper, leads you to, I think, a different governing law for
Well,
the claim to the extent it is based upon
Well, the claim
restriction
will
of
lead you-
competition in a...
It would lead you to, but that's an outcome of the analysis.
I agree.
Yeah.
But
It will lead you to the governing law that governs their claim. That's not so
Which may-
horrendous because it's just the feature of collective
no,
proceedings.
I fully understand you'll fully understand your criticism of the tribunal for focusing on how the case would play out or how the issues in the case.
Yeah.
But I'm just identifying before we get on to section 12 that the consequence of your analysis here particularly is that you will get a variety of different
Yes.
governing laws within the class of within the collective proceedings in this case.
That's right.
At least if you stop the clock at the end of section 11 2C.
That's right. I don't shy away from that. I know that's a target for section 12. I do understand that, but
That's right. I'm just making
Yeah.
sure I've got my feet on the ground before we get to section 12 because that
Yes.
is, I think, the logical place you get to on
It is.
section 11 2C.
but that is the consequence. Although I appreciate this court's got to look at practicalities, but we say not as a part of the applicable law exercise, because what law governs a claim shouldn't be determined by the practicality of trying it, bluntly.
No, but on one level, and I'm not saying this case, but on one level, if this were identified as a problem, it could go to the question of whether it's appropriate to certify collective proceedings.
And it goes to the definition of class.
Yes, it does.
And so the reason why I think I can say to you it's not part of the applicable law analysis, and it'd be incredibly dangerous to allow collective proceedings to
Sorry,
determine the application of statute.
Sorry, I'm running ahead in my thoughts in relation to section 12, and it's probably not a good idea to let my mouth loose at the same time. So I'll shut up for a minute and we'll get to section 12. Right.
Just to make that point good, I appreciate that that is a target, as I know, particularly with this court, where I appreciate a familiarity with collective proceedings and their purpose. But what I would say is that's why I have been making the point that Lord Legate and Lord Sales made, that the collective proceedings is a wrapper. In fact, in the minority judgment, they referred to, a very powerful minority judgment, they referred to the potential abuse for collective proceedings. And the fact that there are multiple claims doesn't determine the applicable law, because you have to just accept that if this is the analysis, then the consequence may be that there will be different governing laws.
As a matter of legal analysis, each individual claimant has a whole series of claims.
That's right.
Because on each occasion that the claimant pays whatever he or she pays, if that payment has been artificially increased by virtue of the myth, then it has a claim for that in respect of that transaction. And if that transaction is one with a French merchant, then you say that the restriction on competition there is a restriction on competition in France. And the fact that for another claim the restriction on competition is in England, or that the bulk of that individual's claims are actually English law claims, is neither here nor there.
It's neither here nor
Because
there.
you can't change the nature of the analysis by saying, oh well, this is a collective proceedings regime, so it has to have a different law, a different approach to applicable law. Well, if that's what Parliament had intended, it could have inserted a section 47F.
Right. And what this goes to then is the definition of the class, and if there are practical issues, but in reality,
Okay, I will let my mouth run loose for a second there, just because it's either you have to define the class or the claims which are within the collective proceedings more narrowly to make it work, triable, if you otherwise would have a multiplicity of applicable laws if those applicable laws gave rise to different issues, and we just don't know at the moment. Or it might be said, there's an indication from Parliament these things should be capable of being tried on a collective basis, and you need to choose a different applicable law to make it work.
But there's no indication of the latter.
Well, that's
would
the
need
debate we may
express
get
words.
to in relation to section 12.
That's right.
Because the question is whether a desire for vindication of collective rights, including those in relation to purchases from other jurisdictions which might have different applicable laws, might lead you to choose a different applicable law for the collective proceedings. You say no. If there's trimming to be done here, you don't do it that way. You trim the class and you take out the claims which might give rise to impracticability or otherwise in having a multiplicity of applicable laws.
Well, and if they did, so there are 3 points to be made, I think, in response. The first is that you can't in any way, consistently with the collective proceedings regime, suggest that the law governing the cause of action would be different because of that regime. Because the very purpose of that regime is it provides a wrapper and it gives benefits to all rights on the proof of damages, but nothing else. You have the cause of action. And that's precisely, I can show you the passage in Lord Legate's and Lord Sales's judgment. And I'm not, even though it's a minority judgment, I don't think that particular aspect of it is challenged or would be challengeable looking at the regime. And it's a very powerful judgment in that particular area. So you can't suggest that the regime, it means that you would analyse the cause of action differently.
Yeah, so I've led you wrongly, and I shouldn't have done this, into starting to run your section.
Well,
12
I'll do that now, and then I'll come on to it, because it's quite a fundamental point. The second point is, when you talk about tailoring the class, that assumes that the trial in very sophisticated courts in this jurisdiction would be impracticable, and that the different applicable laws would necessarily, in every case, because we're looking at a point of principle here, require some trimming or not. We just don't know that. It might go to,
Well, different applicable laws may have no different
exactly,
features.
exactly.
So
But
it just,
then
it
you're
just,
running this point for a reason. Your client is running this point not because it's interested in an abstract analysis, but it's running it because it thinks it will be redound to its benefit because of the application of foreign limitation periods.
Right, but that's the point I'm going to come on to, because the second, that's why I said there are 3 points. The second point is that you don't know there are going to be difficulties, differences at all as a matter of principle, or certainly any difficulties as a matter of principle that could lead you to the conclusion of changing the law or trimming the class. The third point is that actually the real danger of with respect to my Lord Justice Snowden's posited approach, testing me, I appreciate, is that you could, through the back door, deprive a party to litigation of an accrued limitation defence that they would be perfectly entitled to. So by the back door of saying the law is different, which is absolutely not what this jurisdiction has, the approach this jurisdiction has ever taken to limitation.
Yeah.
So it would have consequences that would be unforeseeable and, again, dangerous if one tries to use applicable law, either under Section 11 or 12, to tailor practical difficulties that you don't know exist. And that's going to be the essence of the submission I make on some of the approach taken on
or even
Section 12.
to get round actual difficulties which you can identify.
Correct.
If, as you say, the consequence is that it deprives defendants of limitation defences.
Exactly.
Well, if you're right about everything else, and merely because it's a collective proceedings regime, you can't
No,
avoid the fact that there may be claims that are time barred, and that
you can't.
there may only be claims for £17.50 or whatever it is, but if they're time barred, they're time barred.
That's right. And in fact, here, the application of different laws may be quite a quick process, because if that's the point they go to, the question is, are they or are they not time barred? That's not going to cause great difficulties in the management of the case.
In paragraph 69 of the CAT judgment, it refers to this being a minor part of the transactions. Do you have any idea of what sort of scale we're looking at?
About 250 million Merricks, that's including interest.
About 250 million including interest.
Sorry, 250 million
Pounds including interest.
including interest out of the 46 billion or whatever.
Correct.
And 46 million to the number of consumers.
46 billion is the number of consumers.
No, it's the number of consumers, 17.
17.
17?
We're down to 10 billion. We're going down all the time. Is it 10
So
billion?
it's
About 3 or 4%.
But then the two, anyway.
10, it's 10 billion, isn't it?
Yes.
Can you try and agree it between you?
We'll
'Cause
agree
I
between us,
think
but
there's lots of nodding.
I can hear this.
2.5,
Sorry, I feel slightly like a
About
game
2.5,
show host
3%.
on the different figures, but I'll find out. But the point is,
Well, it may not be agreed, but I mean, at least we can.
at least we've got a
what the
competing
position is.
submission. We'll come back to you on
It's in
that.
the region of 2.5%, 3%,
It's,
something.
but in terms of the total amount of money, it's
Substantial.
it's relatively small. But in terms of looked at on its own, it's a large amount of.
Senate Appropriations Committee comment.
Yes, that's right. But the point is, these sort of considerations are VTB, according to VTB.
Yeah, precisely.
According to VTB, this cannot form any part of the assessment of Section 11, and we'll come on to see it doesn't form any part of the assessment of Section 12. But it shows you, in a sense, it's almost showing you the type of debate that one could end up in if one goes down this route, rather than just simply identifying the elements of the tort. And it's precisely the mischief that one shouldn't get trapped into. And if something different is required for collective proceedings, then that does need to be set out generically, not through the back door of a particular individual case, as here.
It boils down to focusing upon where the merchant and the merchant acquirer's banking facilities are.
Yes,
That's the pivot of it.
it is.
And you say that's the fact which most reflects the relative importance of the components of the tort.
That's right. And the consumers
The claimant is.
and the consumer's loss is of much less significance, they're the third group to have incurred the same alleged overcharge, first group being the acquiring banks and the second group being the merchants. They're two further removed from the elements, and as we've already said, the consumer's claims involve remote sales by non-UK merchants. So the sales could have been made to persons anywhere on the planet, because that was my Lord Justice Snowden's point. But the tribunal's conclusions just from that point obviously collapse into the definition of the class. And had the class included persons making purchases while domiciled in other jurisdictions, there would have been multiple locations of loss.
This is the point you make in paragraph 33 of your skeleton.
Exactly.
I wonder if, I mean, if there's passing on, then there's really, that's just simply the mechanism by which the consumer suffered all the loss. So the fact that their first, second, third is neither here nor there, those up the chain had the market power to be able to pass it on.
Yes.
But it's perhaps a more relevant way to look at it, which is the restriction of competition is never passed on. That occurs
Exactly.
at the merchant level. There may
Exactly.
then be ripple consequences passed on or not down the chain.
That's right.
That's why I think the pivot of this, if it's right or wrong, the pivot remains the location of the merchant
That's
acquiring
right.
banking facilities.
And that's why I said, and it may not be the best way to put it, the passing on element isn't an element of the tort, it's how the consumer's proving it
It's
has
an
suffered
element
the
of
loss.
causation and loss.
It's an element of causation
It's an element of the tort. It's not necessarily an element of the breach of duty.
it's an element of how the consumer shows
Yeah.
it has suffered causation and loss.
Yeah. Section 11 is about a tort,
That's right,
not a breach.
exactly.
Breach is the regulatory provision.
But the loss is the overcharge,
Yes.
not necessarily the consumer's suffering of the loss.
The loss in the claim is that which they've suffered.
That's right. But it's the overcharge is the way you would look at the loss, and they prove that they have suffered the loss through the element of passing on and how much of it has or hasn't been passed
Yes.
on. In which case you're also tying back into it how much has or hasn't been passed on
course.
as well.
Yes.
Yeah.
That then takes me to section 12 of the
So that's the warm-up. Now we're getting down to the real meat.
Yeah.
I do hope not, 'cause I think I've only agreed a limited amount of time for this. So, the 4 points on section 12, which are, and section 12 is addressed at paragraphs 37 to 51 of our skeleton argument. And first of all, and this is absolutely crucial, the threshold to displace the general rule under section 11.2c by section 12 is a high one that only applies when it would be, quote, substantially more appropriate for there to be a different governing law. And that is why Lord Clark described it as exceptional, a very rare case, and as my Lord Justice Snowden put it, a safety net flex. That threshold is not overcome in this case, and indeed the tribunal didn't even properly grapple. They said it was a high bar, but they didn't grapple with what that meant and why it was an exceptional case. Again, they mirrored the same error under 11.2c by saying it's whether it's strongly contested in the particular proceedings, and you can't bring that question into the 12 analysis. The second of the 4 points is that the tribunal approached the issue on the incorrect assumption that Mr. Merrick's case on causation is an issue wholly or substantially connected to the residence of the class members. And that in itself was wrong. Thirdly, the tribunal erred in its consideration of factors relevant to the parties, mistakenly finding that neither MasterCard nor Mr. Merricks has connections to the countries where the restriction of competition occurred. And fourthly, the tribunal erred in its application of section 12 by reaching a decision on applicable law by reference to the limitation consequences, and that's one of the points we've just been debating. The possibility of different limitation periods for domestic and cross-border purchases is not a reason to apply a single governing law. So, turning to the 4 points, the starting point is to look at section 12, please, which is in the authorities bundle at tab 5. And we've already looked at 4, which is the general rule in 11c. And And then if we go to tab 5, it's the displacement of the general rule. You see that in the heading. So you see, first of all, you have to displace the general rule. I'll show you Lord Clarke's judgment on that. It's tab 5, my lord. And then you see from the wording of 12(1)(b) that what matters is the significance of any factors connecting the tort with another country. And this is reinforced at 12(2). The factors which may be taken into account for the purposes of this exercise are those which are connecting a tort with any country. So 2 points. 1, you've got to displace the general rule. And 2, the exercise remains firmly upon the connection of the tort with a country. It's not about, again, the actual proceedings. So it's not an invitation to consider the way the tort has come to be argued at a subsequent hearing.
Are there any cases where Section 12 has been successfully relied upon?
I will check that. The question is, Section 12 has been successfully relied on in relation to 11(2)(c).
Well, that's what
Exactly.
I'm not so interested about
Exactly.
personal injury cases.
Before I blithely answer.
I think there are personal in the
They're
personal
personal
injury
injury
context.
ones, but they wouldn't be then 11(2)(c).
Hang on, what happened in VTB?
VTB did allow, said it was Russia.
Yes.
Yeah.
Yeah, we can look at that. Right.
Yeah.
And that may be where the exceptional, we'll look at the exceptional language. Secondly, Section 12 only displaces the general rule of the significance of any factors connecting the tort with another country make it substantially more appropriate to do so. So you've got the second high threshold, if you like, 2 high thresholds. So can we look at VTB then in the Court of Appeal decision, which is Authorities Bundle 25, tab 25.
And just to be clear, when we're doing this, because you need to look at 12(2) as well, I mean, we are no longer looking at the tort at the time of commission of the tort necessarily. Section 12(2) does talk about the consequences of the events. So we're not as constrained to the commission, the commission events, are we?
But what you are looking at on 12(2), which I think answers why we don't do the inquiry the tribunal went down, relating to the parties to any of the events which constitute the tort, or to any of the circumstances or consequence of those events, i.e. those events that constitute the tort. So what you're not looking at is the argument at the stage of the proceedings. You're still tied into the events of the tort.
I understand
Yeah.
that, yes,
Yeah.
but we're no longer.
But you're not looking at the point
as-
necessarily just the point of infliction,
Yes.
but
which
you
I
are
think-
looking still at the events of the tort, not at the events of the proceedings. Or, quite frankly, the consequences of the way in which the case has come to be argued, i.e. the tribunal's limitation consequences.
But it's
So
a
not events of
non-exclusive
tort.
list as well in 12(2), because it says they include. Doesn't say that that's an exclusive list.
No, but it
So
includes,
the factors you can look at are not constrained by reference to the time when the tort is committed.
no, that I accept that,
And
but
that
I-
must be right because of the circumstantial consequences.
exactly, I accept that, but what I don't accept that enables an inquiry into how the torts come to be argued, i.e. the events of the proceedings. And that is the exercise the tribunal wrongly entered into.
Okay, we're going to have to look at this more carefully, because it does talk in terms about for determining the issues arising in the case.
Well, the issues arising I'll come on to, but it's still tied into constituting the tort. And the tribunal's inquiry is constituting the proceedings. So if we go to VTB, and it's paragraph 149. So The working assumption, just before I ask you to read this, and the tribunal said this as well, is that this court and the tribunal determined that the applicable law was where the restriction of competition arose, not the loss. That is the starting point, that you have determined that the general rule under 11.2c leads you to that conclusion, that it's the restriction of competition. And so you start from having undertaken that exercise to then asking yourself, is there something so significant that you are going to displace that rule and it's displace that conclusion? So that's the starting point of the analysis. And then 1.9, if section 12 has to be considered, the following additional propositions arise. The exercise to be conducted is carried out after the court has determined the significance of the factor and whose law. At this stage, there has to be a comparison between the significance of those factors with the significance of any factors connecting the tort or delict with any other country. So connecting the tort or delict. The question is whether on that comparison, it is substantially more appropriate for the applicable law to be the law of the other country so as to displace. So it's not, if you like, chronological, we've reached this conclusion, but now we've got an alternative analysis. You have to be effectively saying that you're going to set aside your conclusion because you are so clear that it is wrong based upon something else. And the something else, 9, the factors which may be taken into account as connecting the tort or delict with a country other than that determined are potentially much wider than the elements of the events constituting the tort in section 11. So it's not just restricted to the legal and factual elements of the tort. They can include factors relating to the party's connection with another country, the connections of any of the events with which can constitute the tort or delict in question, or the connection with another country of any of the circumstances or consequences of those events which constitute the tort or delict. They can include, and here are the examples. And I'll just show you, just to clear this point off as we're in the judgment, paragraph 150 at the end. My own friend relies on the quintessential evaluative assessment, but we say the point is the court has the power to interfere with the assessment if it's satisfied the judge made such an error. And of course, if there was an error of law, and we say here in both 11 and 12, there was an error of law in the tribunal's approach that I've shown you, and I'll show you the one in section 12. And then, but you see in paragraph 158 of this case, an answer, I think, to both my Lord Justice Snowden's question and the Chancellor's question, based on section 11.2c alone, our tentative conclusion would be that the most significant of the events constituting the tort of deceit took place in England, so the general rule. However, we are not convinced that the VTB has far the better of the argument. It seems to us the arguments are evenly balanced. So in this case, they almost didn't actually reach the conclusion.
Now, there are two different causes of action. One is deceit and one is conspiracy. They're just dealing separately with the two.
Yeah. But that means in both cases, in relation to conspiracy,
They're only saying this, aren't they? Because they're looking at the leave to serve out, permission to serve out.
yeah.
Yeah, well, yeah. What the Court of Appeal did was to say, if it had been left at 11.2c in relation to deceit,
Exactly.
English law, but in fact they then go on to say, but in fact, section 12, we think Russia.
That's right. But all I'm pointing out to you is that on deceit, they say it seems to us the arguments are evenly balanced. On conspiracy, we think there's considerable significance. And our inclination say in relation to conspiracy, the arguments constituting that tort are very
That's because
evenly balanced.
that's because the facts are different. I mean, the deceit was a statement made from Russia to London.
That's right.
Everything acted on in London, and in relation to conspiracy, it was all the people in Russia doing what you you shouldn't
It's part
do
of
if
the
you have
That's right, but my
conspiracies
point is,
in Russia.
what they're saying here is that they are saying our tentative conclusion, the arguments are evenly balanced. Now here what I would say to you is if you go through the 11.2c analysis that I'm positing to you, there's no tentative conclusion about it at all because there's no evenly balanced. There's a very clear finding under 11.2c that the law would be where the restriction of competition is.
In our current
In our
case.
current
Sorry.
case. That's the point I'm
Sorry,
making.
I thought you were talking about this case.
No, no,
EU
that-
VTV, sorry.
I'm just making the comparison. I'm not,
okay.
I'm not saying, I'm not sure how much difference it makes because they do say there's a tentative conclusion. I'm just saying to you that that's a relevant point. That means in both cases we have to go on to consider section 12. And they say we have to ask, is it substantially more appropriate for the applicable law of that other country to be the one that determines the issues in tort arising in this case? And they do go on, as my Lord Justice Snowden says, to consider that Russia is the right place here because they have different factors, and we see that.
It's quite difficult actually to, without having Mr. Justice Arnold's, as he then was, judgment in front of you, to actually pick through this bit of the judgment.
It is, we may have to get that for you, so we can pick through that. To the extent it's going to be suggested that it's a wider inquiry that would be relevant to this case. If I can take the point of principle, and then we see where we get to on that. We get then to the limitation, because although the factors are said to be wide factors, they are still only those which connect a tort with the country. And then if we go to the Authorities Bundle tab 26, at paragraph 205.
Sorry, this is the Supreme Court.
This is the Supreme Court now. And this is page 494 of the bundle.
You get paragraph 188 and 189 of the judge's judgment, Justice Arnold's judgment, are actually set out at paragraph 207 of the Supreme Court.
207, yeah.
So you definitely don't need to.
So no need. So the editors note that the general rule has been displaced on very few occasions. They further observe that although section 12 applies in all cases to which section 11 applies, it would seem that the case for displacement is likely to be the most difficult to establish in the case of section 11.2c, because the application of that provision itself requires the court to identify the country in which the most significant element or elements of the tort are located. Importantly, they stress the use of the word substantially, which they describe as the key word, and conclude that the general rule should not be dislodged easily, lest it be emasculated. The party seeking to displace the law which applies under section 11 must show a clear preponderance of factors declared relevant by section 12.2, which point to the law of another country. And that approach is borne out by the cases. And here you see in paragraph 206, Lord Wilberforce had expressed the view that it would be a very rare case in which the general rule under section 11 would be displaced. And then, as my Lord Justice Snowden has pointed out, these are the factors that led to the displacement of English law by Russian law.
And it's much more, I mean, the point is the Court of Appeal had taken into account a much wider cross-section of facts, including facts relating to the management of the litigation for example, and I remember, but I can't see it, there were, you know, where the witnesses all were, for example, etc., etc. So it was a much wider review that the Court of Appeal took. But then the Supreme Court's saying, no, that's not enough.
That's right, precisely.
But the Court of Appeal at least did open the door to factors well after the events constituting the tort as being relevant to where it would be best to determine the issues in the proceedings.
Yes, and I said I accept under here it's not the moment of infliction, but before you even get to this, you first of all have to be satisfied that you should be in a position of displacing, and that means it's a very high bar to show that, as I say, a very rare case, that it will be, there's a substantial connection which should displace the analysis you've already gone through. And the 11.2c analysis has already pointed out that loss of the consumer would not be significant enough compared to the analysis of...
Yeah, I think we've got to be careful about reading the words very rare into the statute. I mean,
Yes,
they're
no,
not
I
there.
understand
I
that.
mean, you just have to go with the statutory wording, don't you?
Well, except there is authority from the Supreme Court interpreting it as saying it's a high bar, and citing Lord Wilberforce's and saying here that approach is borne out by the cases in para 206. So the exercise involves...
The point about the wider considerations that my Lord made, if you look at paragraph 209, isn't Lord Clark accepting that those could have been relevant? I mean, what he does here is say the Court of Appeal got the end result wrong because they shouldn't have concluded that it was Russia. But he's not saying, as I read paragraph 209, that the Court of Appeal erred in principle in having regard to wider considerations, which might, as my Lord said, have included things like where witnesses were located.
Well, what's cited
The
in...
centre of gravity of the dispute.
But what you see in 188 and 189 is the connections of the parties to Russia, common ground that the parties were managed, the connections of the events constituting the tort to Russia, the negotiations mainly took place in Russia, which relates to how the tort occurred, the misrepresentations, that's part of how the tort occurred, were made and mainly received in Russia. And it was, they concerned the performance of Russian companies. The valuation was based on information provided by Russian management. The reliance was primarily in Russia. And it was the Russian companies primarily dealing with default and enforcing the security. The secured assets were in Russia. The discovery of the fraud took place in Russia. The economic impact is Russia. Now, the factors that they were looking at here, primarily here, and I accept the discovery of the fraud maybe obviously post-dates the tort, but you see a large amount being focused on the actual events relating to the tort itself, which is how the statute is framed, not how the tort comes to be brought in an action and who the identity of them are bringing the claim, necessarily.
It's mice.
It's nice.
Really nice.
Sometimes.
And then you see at 209, should I wait or carry on?
They just have to speak a lot louder, I think.
I don't think that helps. I don't think turning on microphones off helps. We've had this problem before. That's all the rules that causes it. It's not your mics, is it?
No, I think it's the live stream.
It's the,
I think it's the live
I
stream.
think it's the live stream, do you? Can you turn the live stream down? Can you turn the sound down? Well, you better get an engineer here, man. Who can say can deal with this? Where's what's his name?
I suppose like
What?
well, at least we're not in the afternoon.
No. Do you think you can struggle on to 1 o'clock? Because I'll make sure it's sorted by tomorrow morning.
I'm fine, it's whether you're happy, it's more really for the listener than the...
No, I mean,
Speaker.
we're fine. Okay, let's just carry on.
So at 2, I'll try and raise, if I'm shouting, please tell me. At 2:09,
Yeah.
the Court of Appeal, it said the Court of Appeal did not pay sufficient regard to the fact that Mr Justice Arnold, as he then was, was not considering section 12 of the Act, but the broader question of forum convenience. Further, the Court of Appeal focused not upon the particular tort or torts, but upon much wider consideration. As Dicey observes, section 12 expressly focuses on the particular torts. I entirely accept that some of the other considerations were capable of being relevant under section 12.2.
He didn't say which ones those were.
But I can see no basis upon which, etc. But what you can see is that what he's saying is, Dicey makes it plain that you've got to focus upon the particular torts, not wider questions of forum convenience. And then he cites points that should have been taken account in relation to the torts about the loss being suffered in London as a result of VTB entering into contracts in London.
Yeah.
And
What
those
is
are
meant?
connecting to the
Sorry.
torts.
What is meant in 12.2? Factors relating to the parties. The parties have to be the parties to litigation. What's that meant? What does it mean in 12.2? 12.2 identifies 3 factors. If you put a colon after relating to it, factors relating to 1, the parties, 2, to any of the events which constitute the tort or delict in question, or 3, to any of the circumstances or consequences of those events. And consequences suggest more of an ongoing, eventuation of something or other. But parties must be parties to the litigation, not parties to the breach itself.
I think it would be parties to the tort, as in both sides, but
what does that mean then, if it's parties to the tort? I mean, a tort is a wrong. It's a wrong
That's
that can be
right.
righted through a claim. So that means the parties to the litigation.
And if you look at what he goes on to say, that because the claimant was the English company, or the English subsidiary, and the loss had been suffered in England.
but which was induced to
But
enter
then
the
he said the
facility
position would no
agreement.
doubt have been entirely different if the claimant had been VTB Moscow. So he's obviously got in mind there the identity of the party to the litigation.
I can see that in a way,
Some abstract assessment of the tort.
but what I would say is that there's no doubt that section 12, and I said this to Lord Justice Snowden, goes wider. I mean, it clearly goes wider on its face. You can see that from 12.2, and it clearly, because it goes beyond the elements of the tort, and it clearly goes wider than just the date of infliction of the tort, because of the consequences point. I would have read parties as parties to the tort, but in a way it doesn't matter to me if it's parties to the litigation, because I have to accept that you would be looking at the consumers here.
Yeah.
So I accept that either way. But my point is that it's all got to connect back to the tort.
Yeah, I mean, can I sort of I thought that the point you were going to make is this. Let's look at one factor that is referred to by Mr. Justice Arnold at paragraph 188
Yes.
of his recorded judgment, which is why I think it's important to look at it. Counsel for the defence submitted the following factors pointed to Russia being the natural forum. First, the connections of the parties to Russia the control, the litigation being managed. The criticism of the Court of Appeal and the reason the Supreme Court said that was wrong is at the very beginning of 209, which is what you read out to us, which is that was Mr. Justice Arnold dealing with a different question, which is forum conveniens, which is where you do ask, for example, where is it most convenient to try the issues between the parties? And you do look at their things like, where are the parties, where are the witnesses, where are the documents, etc. Supreme Court saying Court of Appeal got that wrong when they're looking at Section 12, because Section 12 is dealing with forum conveniens. We know the case is going to be tried here. What Section 12 is dealing about is what's the applicable law to determine the issues. And the applicable law can't be determined by who's managing the parties in the litigation.
Exactly.
Therefore, the real problem that Lord Clark was identifying, I think, with the way the Court of Appeal got it wrong is they fastened on to a part of the judgment below and some factors of the judgment below which were actually dealing with not applicable law at all, but forum conveniens.
That's
And
right.
That's why you, to use your expression a little earlier, you say you focus back on the tort and the
That's
events that.
And that's the language of the statute.
Yes, which is what Lord Clark is saying, I think.
And that's consistent
very
with-
crisply at the start of 209 when he identifies where the Court of Appeal went wrong in giving too much weight to factors that were relevant for forum conveniens.
That's right, and that's why he ties back into elements of the tort when he looks at cites what should have been taken into account and wasn't. So what I'm saying to you is, in a sense, I can put this two ways. The cleanest way for me is that whatever elements do or don't come into 12.2 beyond section 11, first of all, you never get there because it's going to be incredibly difficult to displace the bar here where you have not just tentatively but firmly reached an analysis that is substantially the conclusion under 11.2c. You then, and you had discounted under section 11.2c already the idea that the fact it's a follow-on claim or the consumers have suffered loss changed the analysis. To then say under 12.2 that those factors would displace your analysis would be quite an unusual, as the Chancellor said at the outset. It's going to be quite difficult because you're effectively going back on what you've already done.
On the same ground.
On the same ground, which is why it's a rare case, to use the words of Lord Wilberforce, or a high bar, to use the words of Lord Clark. But in any case, the reason it matters not then what the wider analysis is under 12.2, to my case, is that what we know is that the wider analysis being posited is not to do with the tort, it's to do with forum conveniens type arguments, but even worse than that, it's not being said, oh, it should all be done in England because of forum conveniens arguments, which wouldn't be permissible. It's being said that in your crystal ball, you can determine that because it's a follow-on proceeding and there's loss, the very same arguments you've rejected, that somehow they come in through the back door under 12.2 just because wider considerations are permissible. And what I would say as a short point, but I'm going to go through it a little bit more, as a short point is, those arguments don't get better through repetition under section 12 than they were under section 11. Because the reality is that they're bad points. You can't determine, to use my Lord Justice Snowden's point, you can't stand back and determine applicable law by asking yourself what's in dispute. And that's the same error that was made in 12 as it is under 11, and it's no more permissible under 12 than it would be under 11.
What's the purpose of 12 then? Your starting proposition for 12 is that, taking our France-England example, it's the elements of the tort are more significantly connected to France. So that's your starting proposition before you get to 12. You then say, applying 12.1, that even though the strongest connection is to France, it's, quote, more appropriate that we come to some other country, England. So in a sense, you take into account the strength of the connecting factor to France, and then you've got to say, what is it over and above that which then takes you back to England?
And substantially over
Oh,
and
sorry,
above that.
can I just,
Yes, of course. Yeah.
sorry, can I just interrupt for 1 second? Just in the question, without wishing to in any way pick my lord up, it's not taking you back to England. It's selecting English law rather than
Yes,
French law.
okay.
Yeah.
And I think that's the
That's the
error
answer.
that the Supreme
Yes.
Court identified with the
Exactly.
Court of Appeal.
Exactly.
The Court of Appeal
Looking at the forum.
Exactly.
forum, not law.
Exactly.
Which
And
is
what the
the challenge
tribunal's
of
done is
considerations.
what the tribunal's done is even worse.
Yeah.
It's not even the forum, it's case management concerns.
We all know this case is going to take place here. It's just a question of which law you use. I think this is
Exactly.
what this is actually about. And so, but with that gloss stroke correction of my lord's question,
That's
what's
quite
the answer
important,
to his
isn't it?
question?
Because then that is important because it informs what's meant by more appropriate. So you've got a choice. It's going to be heard here.
That's right.
Which law? So it is those factors which make English law more appropriate than French law, which may then relate to the parties or events which might arise, which are the factors in 12.2. But they've got to somehow have a nexus with the law as opposed to the forum.
That's right. Exactly.
So that limits your net in 12.2.
It does. And the reason why Lord Clark, and I think the Chancellor was saying, it's limited even further is you can see that there may be, if you go back to 11, section 11.2, which is at tab 4 of the authorities bundle, you can see there may be more scope in 2A and B, but in C, where you've already determined that the most significant element of those events occurred, in order to say what the applicable law is, you can see it's quite hard then for there to be much scope for it being substantially more appropriate nevertheless.
Let me just
As
postulate
a matter of law.
Can I postulate a wild example? Suppose you go through 11.2c and you say it's perfectly plain looking at the tort that is alleged to have been committed in this global world that the applicable law is the law of North Korea. But the parties are all in England.
That's a
Yeah.
forum point though.
No, wait a minute. We're litigating here, and they say, okay, I can see going to 11.2c that the applicable law should be the law of North Korea, but we can't get any witness, we can't get any sensible expert evidence out of North Korea. Nobody knows what the law is. On this particular issue, is it not more appropriate to choose English law as the law? It's that sort of, it's an extreme case, but it's looking at, it could be looking at the identity of the parties. So I'm just trying to get, it's factors relating to the parties. It could just be that in an extreme case, practicality might intervene.
I would push back on that, and I think
I know, I was putting it to you because I didn't expect you to sort of
overnight
accept it, but-
I'll try and answer the
Well,
Chancellor's
I think
question.
your answer to the point would be that is
A forum point.
committing the same forum convenience
Exactly.
heresy as the Court of Appeal did.
Exactly, and more than that, on the example you've given, if you couldn't get sensible expert evidence out of North Korea, you would assume it was the same as English law.
Well, precisely. I mean,
But
sorry,
you
I'm
can
trying,
do that by applying North Korean law.
Yes, sorry, I'm trying not to commit the same form non-convenience.
You could do
because
that by
I was-
applying North
Because
Korean
I was
law.
focusing on the let's say the difficulties of getting evidence about a foreign law. I'm not saying it should be tried over there. I'm just saying if that's where 11.2c took you, there might be, and I can't sitting here dreaming up the scenarios, but you've got a whole raft of people behind you, probably could, and then knock it down. There might be reasons why you wouldn't choose that 11.2c law to be the law which you would want to have determining the issue in the proceedings for other reasons. But I accept it would need to be an extreme case.
So I think I agree it would have to be an extreme case.
Because you have to find some reason for section 12.
Well, section
And
12
section
could
12
apply
too.
though, as
Because
I
don't
said.
tell us, you can't tell us it'll never apply because it's the same factors as you have under 11.2c.
But I'm not saying I'm not saying it would never apply. I'm just citing the court that it's a very rare case.
So it would be nice to have an illustration of the sort of circumstance
I will
in
try
which
and
it might apply.
I'll try and come up with that overnight. But what I would say to you is, on your example, you see, first of all, it is, with respect, you used the words choose which law, and that's the error in a way, because you can't choose which law. It's got to be within the boundaries of the factors connecting in Elect 12.2. The second is, it is a forum consideration, because in that example, you wouldn't be choosing English law. What you'd be doing is it would be North Korean law, and in the absence of evidence, North Korean law would be assumed to be the same as English law, but it would be North Korean law.
I suppose the way you put it is, if you look at 12.1b, you still have to, in order to get the other law, as it were,
Exactly.
you still have to have factors connecting the tort or delict with that other law.
Exactly. And then it's got to be substantially.
And so it's not the people.
It's not the people.
It could be factors relating to the parties, because that's what section 12.2 does say.
But then it has to be such a substantial connection. It displaces under 11.2c what you've already found to be the most significant element.
And not falling into the forum
And
non-convenience
not falling
trap.
into the forum trap. And not falling into what I would say is 1 degree worse, which is what, with respect, the tribunal did, which is not even a forum trap, it's case management, that it'd just be a bit easier to have only one law of limitation.
Would one example of 12.2 be the fact that, so far as the parties are concerned, they were the victims because there was pass-on from the merchant from France to the United Kingdom, and therefore you would take that into account as a relevant, significant connecting factor, even though that was a circumstance which flowed from the event or a consequence of the event. And that might be a fact which militated in favour of domestic law over French law. It would relate to the parties. It would be a circumstance of the events, the event which was the restriction of competition, which was constituent of the tort.
But then you would have to say that factor which you had not found to be a significant element of the tort, the loss suffered, because I think you pulled me up on it being the loss by the claimant, not just just any loss. You'd already just said that wasn't this most substantial element, so that same element can't then displace what you've already found.
I'm not so that necessarily follows from the relationship between sections 11 and 12. 12.2 is almost saying it's a party, so it's a claimant. There are events which constitute the tort which had consequences, and the consequence was that there was pass on from France to the United Kingdom, where the party is based.
But then what you're actually saying is not, with respect, not any of the pass-on aspects, but where they're resident is the factor you're taking into account.
It's a factor relating to the parties.
Right, and then, but I'm going to come on to that, because the tribunal found residence, and if residence was going to be the factor of displacement, then it would always displace, because residence then would be relied on every single time.
We might do, we might not.
But it wouldn't be a very rare case if that
Maybe.
was a relevant factor on its own.
You say whatever else it is, it's don't fall into the forum trap and don't fall into the case management
Exactly,
trap. Get that?
exactly.
And it still would be nice to have some vision of
Yeah.
the
I can see that.
scenario in which you say section 12.2, or sorry, section 12.1 would operate, having regard to section 12.2. So
In a 11.2c case.
yeah, so get to 11.2c, get to your result, which is what 12.1a says. So do your 11.2c exercise, which answers the question of 12.1a. But then you've got a factor which you have said is not the determining factor for 11.2c purposes, but it is the factor that you identify in 12.1b, and it's the inversion of the importance of those factors, which satisfies the test set out in 12.1, the bit after the A and B. And I'm just trying to visualise what scenario that might be.
Well, if I can come back with an answer,
But I get where you say, I get you say what it isn't, and in
I
a
agree.
sense you don't have to.
and in a
say-
sense I don't need to, but I understand the comfort of knowing what could fall in, and I'll try.
I suppose the ultimate test is appropriateness in 12.1, substantially more appropriate, and that must be appropriate notwithstanding that when you take the constituents of the tort, it has its strongest connection to France.
That's right.
So it's more appropriate by reference to what? To the proceedings?
Well, it doesn't seem, but that's definitely not the case, because the statute makes it very plain. Can I show you, just before the break, can I show you what the tribunal said? Because in a sense, I appreciate it's a point of principle, but it's also, I do have a specific target to start with of what it's not.
Just before you do that, by all means do it. Can I just say, I just had a quick look at the extract from Dicey that you've included in the bundle,
Yes,
which tantalisingly comes to an end, I think, before it probably
I'll
should.
get more of it.
We haven't got the whole of the thing, but footnote 774, I think it is, identifies, which is the very last page of bundle 4. Don't look at it now, but it identifies the cases, and there are only a handful of cases in which section 12 has
Been applied.
overridden the general rule, and it looks as if one of the only ones that's an 11.2c case is actually Deutsche Bank and Sebastian Holdings, and
I should know about that then, shouldn't I?
thought you'd like that. We had
Yes,
it for another
some
reason
time
in an
ago,
appeal
I'm
yesterday,
sure.
so, but the costs judgment, not the main judgment. And
Yes.
there's another one, I think there are two cases there which look as if they're decisions of the Commerce Court, potentially the Court of Appeal, in 11.2c, as opposed to personal injury. And I'd just be quite interested in whether there's any illumination as to what section 12 is all about in the context of 11.2c displacement of
Because, and you do need, perhaps, you will both want to address the question, substantially more appropriate, this is the point my Lord Justice Green was making. Does it mean appropriate, including for the, given the nature of the proceedings? Is that what appropriate means? Because it does talk about determining the issues arising in the case. Or is it appropriate in a more narrow?
Well, it can't be in the wider sense, because you know that forum is not
No, I'm not saying
visible.
where, I'm not saying where.
Right.
It's, is it more appropriate in the proceedings in our jurisdiction? We know that they're taking place here, it's not a forum question, but does it mean more appropriate, for the ends of justice in determining the case here? For example, I mean, I just raised.
Just show us
Sort of
what you want to show us in the
Yes, it's paragraph
Judgment.
92 of the judgment.
paragraph
92.
92. Yeah.
So this is where the tribunal begin to address section 12. And they say it's the threshold is a high one. Say that it's a broad range of circumstances. And then they say, we have no doubt in the particular circumstance of these proceedings that should be displaced for the purposes of determining the issues that arise by the law of the place where the class members resided at the time they suffered loss. So they have tied it into residence in that way, without going through, we would say, the underlying analysis of how you get to that in the first place. But then you see what their reasons are. And this evaluation proceeds on the assumption that the restriction of competition is the most significant event for the purposes of 11.2c. They then latch onto the issues that arise in the case, which I'm going to come on to
Place the loss.
tomorrow. And then they go to what is the issues arise, and here's the gloss, and are strongly contested in these particular proceedings.
Yeah.
Are not whether there was a restriction. So they immediately move to the same error they made
Well,
in 11.2c.
you say that's the same error.
Same error. They then say in little 2, factors relating to the parties are relevant, and they pin it on residence. And then they make the point that there's no connection, which we say is wrong for the reasons in our skeleton. I'll briefly show you that tomorrow. And then they also try and suggest that the facts of the tort claims, this is little 3 at the bottom, is very different because the majority were made in that purchases were made in the home country, which we say again, the connect. So we say as a matter of the actual connections they took into account, that wasn't right.
Yeah.
Even if, and the approach we say is also not right. And then you see in the end of subparagraph 3, it would be clearly more appropriate, this is a few lines up from the bottom, for the issue of limitation to be determined by a single system of law. So the case management debate that we had earlier underpins this. And again, it's the collective.
Well, that you say is also an error because
That's a complete error,
that's the point
indeed.
about the wrapper.
That's the wrapper. So I just need to address you on the appropriateness test and why this went wrong tomorrow. And I also briefly have to cover common law. I'm behind time.
Well, I was going to say you are behind time.
I am
That's
behind
probably
time.
because we've interacted quite a lot.
Is it possible to start a touch earlier tomorrow and I'll cut my cloth?
Probably can.
I can't remember what I've got on tomorrow, to be honest. There's usually some. I think can you sit at 10 tomorrow? The other possibility is to sit early on Friday.
I'm in your hands.
Well, when will you sit at 10 tomorrow?
Thank you.
And see how we go.
Thank you.
Are you all right with that, Mr. Mitchell?
Yes, I'm all right to start at 10. I'm just anxious that my learned friend doesn't take up too much time in the morning because I was supposed to have started a quarter of an hour ago, and so I'm.
Yes. Well, then, if we get an extra half hour in the morning.
Yes.
And I
if
will.
we have to if we have to sit early at on Friday, possibly even at 9:30, frankly.
Thank you.
Because I really do have to leave by about 3:30 for entirely personal reasons, but you understand it's a Friday. Otherwise I'll get, I won't be here for the judgment. I'll have been seen off elsewhere.
Thank you. And I will, if necessary, just cut my time on 31.4 if I need
We'll
to.
try and interrupt a bit less, but I hope we haven't been too interventionist. Thank you very much.
Thank you very
10
much.
o'clock tomorrow morning.
Court rise in order.